Hello, everyone. Attorney Joshua Micret from New Liberty Law here, and this is your Liberty Minute for this week. Today, we're going to talk about something that sounds complicated when you hear its title, but it's actually pretty simple. A habeas corpus petition. With a recent decision from the Board of Immigration Appeals that changed who gets stuck in mandatory detention, this idea of a habeas corpus petition has become more important than ever. So let's break it down. Number one, habeas corpus is a way to ask a federal judge to let someone out of detention. Now, this is not an immigration judge. This is a federal judge who is much more powerful, appointed by the President of the United States, a much more important position. Habeas corpus is Latin for bring me the body, which sounds like someone's bringing a dead body, but it's actually just an old-fashioned way of a judge telling the government to bring a person in before him so that they can justify why they are detaining that person. It's like the emergency button. A habeas corpus petition is like an emergency button that you hit when every other door is locked, and it's been around for hundreds of years because the button works. It can get people out of jail when other things don't. Number two, as we talked about in episode 5, and as I referenced a moment ago, there was a recent ruling from the Board of Immigration Appeals that made almost everyone who entered the United States without inspection or without a visa count as mandatory detention, meaning they weren't eligible for bond. That decision suddenly put a lot more people into the category where ICE says, sorry, no bond for you. It's like they widened the net overnight with this decision from the Board of Immigration Appeals. And now tons of people who used to be eligible for bond hearings, no problem, now they're not eligible anymore. Number 3, a federal court in California, and we also discussed this in episode 5, said people who entered without a visa should not be treated as mandatory detainees, But unfortunately, immigration judges are not following this ruling. So even though a federal judge said these folks should be allowed to ask for bond, immigration judges in most places are still acting like the California ruling didn't happen or that it doesn't count. It's frustrating. So you imagine someone telling you the rule changed, but the referee keeps playing by the old rules. Number 4, because of that, because of the fact that judges are not yet following this California ruling, filing a habeas corpus petition is often the only real way to get someone released from immigration detention. When the judge in immigration court refuses to give a bond hearing, habeas lets you go straight to federal court and ask for help. If immigration court keeps shutting the door, again, we need to push the habeas button to find another way out. Number 5, the California decision. That decision could still become the law for the entire country, but it's not nationwide yet because the immigration judges, as I mentioned earlier, are not following it. But this decision could be picked up by other courts, and suddenly, in an instant, it could apply everywhere. So what starts in one courtroom could change how detention works for the whole country. And hopefully we see a decision like that soon. So in closing, I am Joshua Micret with New Liberty Law. This has been your Liberty Minute. And as you all know, liberty is a work in progress, our work.